Adjudication was one of the big changes, I suppose, in our industry over the last 25 years, which is a private process. And I think one of the things that concerns me as a lawyer looking across the industry and the development of the industry is, whilst adjudication as a private mechanism works very well on a project-by-project basis, it does tend to stunt the growth in the understanding of how construction projects should work and should be dealt with at a sort of more industry level by looking at how the courts are dealing with the interpretation of those contracts. My concern is that that's true nowhere greater than in the NEC, which has really grown up under the process of adjudication, where perhaps JCT and FIDIC have appeared in court an awful lot more, and you've got a lot more court-based guidance on how to interpret individual terms of those contracts that you don't really have under the NEC. Do you think that's going to stunt the growth of the NEC in the industry because it just becomes too much of a risk, because no one knows really what's going to happen in the ultimate forum in court if there's a major problem?
I would say it hasn't.
Not yet.
Well, not yet, you could say, but while past history doesn't govern future performance, I think that when you go, if you said it to a civil engineer, don't use that bridge until it's fallen down, they'd look at you as if you were stupid. There is a parallel with lawyers saying, oh, don't use the NEC until there's some case law on it. So I think that practically it hasn't. But at the same time, sometimes as a pseudo lawyer, I can quite understand that it would be useful if there was some case law to by and large reinforce what the NEC says.
Yeah. Well, I was going to add to that actually. That is a lack of case law under NEC because NEC is such a great contract, or is it actually because there's a lot of uncertainty around the NEC and parties don't want to go off to a tribunal to get a decision with so much uncertainty?
So if there was certainty, then why would they need to go to the tribunal? Everyone would know what the answer is. So I think you only go to that tribunal because there's uncertainty and there's always nuances around particular cases. I think the drafters of the NEC would certainly say that the contract itself built on all that past case law, that when it was first produced and when it's been revised, they've taken on board case law for other contracts. So there is some underpinning logic to it that the courts can support. I agree that there's not been a lot of recent court cases in relation to the NEC. I think it's because adjudication, as you've mentioned, Rob, has come in to make that private process. But it's a bit of a double-edged sword. Yes, you may get more certainty, but if it's all the wrong answer and not what the drafters intended or what most people thought, then you can see lots of Z clauses and amendments to try and pull it back to where people think it is. So greater certainty, but only if it's the right sort of certainty and the right sort of decisions.
The other thing I think you have to look at is you have to say, well, where did disputes start? They start at site level. And if the site people can understand it better and actually do what the contract says, then there's going to be less likelihood of disputes. And within that, there's the stimulus to good project management, which is to try and head off, avoid disputes. So I think you also have to bear in mind those factors, yet at the same time, there is an element of the lack of case law potentially reduces legal uncertainty. But what clients want overall is certainty of their project. And I think the NEC gives you more of that overall, even though legal certainty might be a bit reduced.
Yeah, to some extent it's very difficult to comment because we can only talk about what we see in court, because we don't know how much dispute work is going on in adjudication because it's a private process and where the issues are in adjudication. That's my biggest concern is, we might be as an industry having 100 adjudications a week on how you measure time impact under the NEC, but we don't know. And I can see as a lawyer that I've acted on multiple cases with very similar issues, but they all come before different adjudicators with different backgrounds with no guidance from anywhere. So whenever a client asks me, what's the answer going to be, it really is, I can't say for certain. And you then have to start looking at what's the background to the decision maker rather than just what's the background factually and contractually and legally, but it's where does the decision maker start from. And I think that's not a great thing for the industry. It doesn't give certainty.
But in fairness, Rob, when you're looking at other disputes under other contract forms, the fact that there is a dispute, the fact the parties can't agree, means there's a level of uncertainty. So in those situations, can you give your clients a definitive answer? that actually the courts will definitely say this? Or is it, again, still in the balance of probabilities? There's still going to be some element of judgment and potential interpretation by that court based on the facts?
Well, I think you can get to certainty on what the contract says, and the uncertainty and the dispute really is about the factual application of that contractual certainty and how you say the particular facts operate in that contractual framework. Whereas with the NEC at the moment, you've got two variables. You've got a varying facts, which with different people relying on different facts, and an unknown quantity of what a judge is going to say in relation to how the terms operate. So rather than having one variable to focus on, you've got two, which makes it twice as difficult to come up with real solid guidance for someone.
But that response is based on the presumption that once a clause has got to court, we have legal certainty. Whereas I believe at some point, for instance, under JCT, there were 7 court cases, this was 10 odd years ago, on the status of the architect's final certificate and whether practical completion had been achieved. Well, if case law established certainty, you wouldn't have needed to have the second case law, the third and the fourth. So I think that once we've got case law, there will be legal certainty. It's a bit of an over-egged argument, to be honest.
I guess the summary then for all of that is that perhaps the desire for case law is a nirvana state, that everyone would like to have the answer to exactly how the court is always going to decide something all the time. But in a practical sense is probably impossible and probably unnecessary, because if your contract's operating properly and the NEC is being implemented properly, you shouldn't ever get to that stage. Thank you very much, gentlemen.
Thank you.
Thank you.